All right, so I'm here obviously to talk about Section 504. So just a few housekeeping matters, as Kim said. Of course, if you have questions along the way, please feel free to put them in the chat. But that being said, as I'm sure you're told at all of our presentations, we are not giving you legal advice today. I'm going to give you an overview of the law. I'm going to give you some examples of, of situations we've dealt with and situations that we are just aware of. But I'm not going to be able to answer specific legal questions about things that are happening in your district. So if you have a specific question, be sure to reach out to your own legal counsel. And if we are your legal counsel, reach out to us, in a different setting so that we can have a privileged attorney-client conversation about that situation. But general questions, absolutely put them in the chat, and we'll do our best to get them answered for you as time permits. So to give you an overview of what we're going to talk about today, I'm going to spend the first section, hour-ish, probably less than an hour, but close to an hour, going over kind of the nuts and bolts of 504, just a broad overview of the law, what it is, where it came from, and how it's developed over time. The handout that you have, that there's a link in the chat, it's really, really detailed. I'm not going to cover everything in the handout, but hopefully that will be a good reference for you going forward. So just you can kind of follow along in the handout, but the slides are really the better way to go, because that's going to track what I'm going to talk about. Let's see. Then for the second hour, I'm going to do the frequent questions that we get in our office about 504. And we'll talk about that. And then at the very end, I'm going to read a scenario to you about a mom's concern about 3 of her children. And we'll talk through, how we would handle those specific scenarios. So if you want to get the answers right to those questions, you'll have to pay attention. There will be a quiz, but it'll be anonymous. So you don't have to, tell everybody what you're thinking. So no pressure. All right, so let's get started on our ambitious agenda. Maya, if you can go to the next slide. Excuse me. All right, so let's get started. The first page in your handout, in your materials, like I said, there's a lot of detail, and I'm not going to spend a lot of time talking about that, but there is a comparison chart between the IDEA and 504, kind of an at a glance, what are the different requirements under each law. And as I'm sure you know, the IDEA is certainly a lot more complicated than 504. It takes a lot more to be in compliance. The regulations for 504 that apply to secondary schools are 4 pages long. That's 4 pages of regs under 504. The IDEA regs are like 600 pages. It's just night and day difference, the amount of regulatory oversight there is to enforce these laws. But that first page in your handout gives you that kind of side-by-side, comparison of the 2 laws that you can go back to and refer to. But let's start with what the law actually says. 504 is part of the Rehabilitation Act of 1973. So by its name, it's been around a really long time. It's super old. It's been around almost as long as I've been alive, but not quite. But it's interesting that we get a lot of questions about 504 when the law has been around so long, and the text of the law, it hasn't changed in all that time. It's over 50 years old. And it's really only one sentence here. I'm not going to read a lot of things to you today, but since we are going to be talking about 504, I'm going to read you the text of the law. Just keep in mind as we go to that because this law went into effect in the 70s, the vocabulary is a little bit different from what we use today. You'll hear the word handicapped. You'll see it in the materials. You'll hear me say the word handicapped. Just know that when I'm using that word, I'm using it because I'm quoting the law and not because that's, because I'm an insensitive person, but that's the term that's used in the law. And in the original regulations, we of course use other terms today. But here's the relevant portion. No otherwise qualified individual with handicaps in the United States shall, solely by reason of his or her handicap, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So that's the starting point. That's the law. We're not going to discriminate against people on the basis of their disability. We're not going to deny them access to our programs, participation in our programs, or the benefit of their programs. We're not going to subject people to discrimination on the basis of their disability. So it's an anti-discrimination law. That's where it starts. And it's about access. And the thought process and the reasoning behind this law is that if federal funds are being made available for your programs, then the federal government is going to require that you make those programs accessible to people with disabilities. So that's really the underlying premise that's going to guide every decision you make under 504, starting with this anti-discrimination, accessibility concept. Now, in addition to the law, of course, we have those regulations I mentioned, just a handful of pages. There's not a lot to it. The U.S. Department of Education is where those regulations come from. The regs, like I said, for K-12 schools are just a few pages long. If you include preschool and post-secondary, it's like 12 pages. I mean, that's like the max. That's all we're looking at. So there's not a lot of text when we're talking about the 504 regs. So you might ask yourself, why is this so complicated? I get a lot of 504 questions. It is a very complicated area of the law, but even for a lawyer, it's hard to imagine how I'm going to talk about a few pages of regs for 2.5 hours, although, I can talk. So give me a topic and a venue and I'll talk about it. But there is more authority than just those regulations. And so that's where you get into some of the nuances. Every time the Americans with Disabilities Act, the ADA, is amended by Congress, those amendments also apply to 504. We have what we call a conforming regulation or a conforming amendment. So every change to the ADA also applies to 504. And that's where we get a lot of our authority. That's how we've gotten some newer interpretations of 504, even though nothing substantive has really changed since 1973. So the most recent ADA amendments were in 2008. So it's been a minute since those amendments went into effect. But those changes were pretty significant. Congress made, really significant changes to the ADA that I'm going to kind of point out a little bit as we go today. But the major effect of those changes was that Congress was telling the courts that up until 2008, they were interpreting the ADA too narrowly. They far too narrowly, really. And so the amendments in 2008 expanded the scope of the ADA to encompass broader coverage, to apply to more individuals. And accordingly, that expanded the scope of 504. So we saw a pretty big expansion back in 2008, and that's where we've been operating under that amended version of the law since then. So other guidance that we rely on is guidance from OCR, and that is the office within the U.S. Department of Education that enforces 504. If you've had a complaint in your district filed with OCR, if you've dealt with a 504 complaint, we call that your opportunity for professional development on how OCR is going to interpret 504. Not always a fun process. It can be stressful, but OCR is who is going to enforce those laws. And so their regulations, of course, tell us how they're going to interpret and enforce those laws. OCR also periodically issues what we call Dear Colleague letters. You may have heard of these before, but those are letters that they put out. They start with Dear Colleague, and they explain, how they are interpreting and enforcing the law. They provide helpful guidance, and those letters are authority that we also need to pay attention to. So we'll talk about some of those letters today. But before I move on, just to kind of explain that legal authority, back to your basic civics lesson, there are 3 branches of government, as we all know, right? We've got the legislative branch creating the laws. That's Congress. They passed, the Rehabilitation Act 504. We have the judicial branch, which of course is our court system that interprets those laws. And then we have the executive branch that carries out the laws. And that includes the U.S. Department of Education. That's part of the executive branch of government. So laws come from Congress because they have to be passed by the legislative branch. But sometimes the law says right in it that they are, giving authority to the executive branch. In our case, it's going to be the Department of Education to promulgate regulations to enforce it. And so that's why, even though the regulations come from the Department of Education, they're still binding legal authority because the legislative branch delegated that authority to the executive branch. And that's how the law is administered. So when they adopt a rule, the Department of Education has to go through a rulemaking process, and it takes a long time. Most recently, you may recall the Title IX regulations that came out in 2020. Those were proposed in 2018. It took a year and a half to go through this process where they publish their proposed rules, and then they get comment, and then they analyze these comments, hundreds of thousands, literally, of comments that get analyzed and then worked into, how they're going to adopt their final rule. So there's a specific process for adopting regulations. And that is what the Department of Education did with Title IX. It's what recently in 2023 happened again with Title IX when they issued another set of proposed rules, which are currently enjoined. I'm not going to get into all that, but it's just so you can have a basis of understanding of how these rules get adopted. So those rules, once they're adopted, they become law unless they're challenged, but they become law. Those are legal authority. The Dear Colleague letters that I'm talking about, though, those don't go through that process. Those are not binding authority, but they do give you insight into how the Department of Education is going to interpret the law, how they're going to enforce the law, and they're the ones charged with the enforcement. So that, it gives you a good basis for your compliance. So they're not actually law, but they are important, and we do rely on those as well. All right, so we're going to talk about some Dear Colleague letters that have been around for a really long time. Some of these, though, they come out, we get whiplash as we have change of administration, differences of opinion on the interpretation of these laws and how they're going to be enforced. So, but those are your sources of legal authority that we're going to talk about today. So on the next slide, the first thing that we're going to talk about is where you start with 504. It's the same place you start in the IDEA. The first substantive requirement under 504 that is applicable to pre-K to 12 is child find. And I do limit that to pre-K to 12. You'll note that this does not apply to post-secondary. So if you are with a career tech center and you run a post-secondary program, just know that child find obligation does not apply in post-secondary. And I have frequently gotten that question. It kind of muddies the waters when you've got two different types of programs and the laws apply differently to each one. But in pre-K to 12, 504, first thing is going to be your child find obligation. So there are citations to the regulations in your materials. Anytime you see that, 34 CFR followed by numbers, that's just the reference so that you know where to find that substantive obligation. All right, so the regulation says you have to undertake to identify and locate every qualified handicapped person residing in your jurisdiction who is not receiving a public education, and take appropriate steps to notify handicapped persons and their parents, guardians of your duty under this law. So you are charged with conducting an evaluation of any child who, because of their handicap, needs or is believed to need special education and related services. So that's your child find obligation under 504. And you may notice that very closely resembles your obligations under the IDEA. It's really the same thing. So when you have a student who is believed to need special education and related services, you're required to conduct an evaluation. So how do you meet that obligation? Well, since it is basically the same obligation under the IDEA, you meet it the same way. You're going to publish a notice over the summer, and that notice is going to say, if anyone knows of anyone with special needs, please come and, have them contact our Director of Student Services. Usually you have a citation to the IDEA and to 504 so that you can accomplish that child find notice obligation in the same way. So on the next slide, and I'm going to spend a significant amount of time on this section and these topics, but what is an individual with a disability under 504? What does that really mean? So first is the obvious one, and that is someone who has a physical or mental impairment that substantially limits a major life activity. an active disability, someone that currently has an active disability. And we'll spend most of our time talking about that. But there are other categories of individuals who are entitled to protections under the IDEA, even if they don't have actively currently a physical or mental impairment that substantially limits a major life activity. And these folks do sometimes get lost in the shuffle, not on purpose, but sometimes we don't know. Sometimes, these situations can arise from information that is, buried in your student records from years ago. And sometimes people just aren't aware of the protections that are afforded to these additional categories of individuals. But an individual who has a record of an impairment is also protected. And that doesn't necessarily mean that they're going to get a 504 plan. I'm going to talk about that part later, but they do have other protections. So typically that means somebody who's no longer disabled. So that might come up if, if there's a record of having been impaired. So maybe a preschooler who was identified, but then was exited from the program or exited, when they reach school age, that person is protected from discrimination on the basis of their record of an impairment. And then the third category is someone who is regarded as having an impairment. And it can be an impairment that's minor, that maybe isn't a substantial limitation, but is a minor limitation, limits a major life activity or limits them in some other minor way that's just not quite as significant. It could also be something that is transitory, something that's temporary. It doesn't, it can also be something that that is perceived as a disability, but maybe isn't a disability. So this is kind of a fuzzy category, right? It's a little hard to identify. But those individuals are not going to be identified as individuals with a disability under 504. So they're not going to be entitled to programming, as I mentioned, but they're still entitled to the anti-discrimination protections under the Act, under 504. So just know that the statute provides anti-discrimination protections for people in all three of those categories. But we're mostly going to be talking about that first category. So I want to break that down first. So there are three concepts to consider, as I mentioned. So it's a mental or physical impairment that substantially limits a major life activity. They have to meet all three of those categories. So before we get too far into what those three things mean, I'm going to mention temporary disabilities for a minute. We do have some guidance on that. Something like a broken arm or a broken leg. Is a broken leg a substantial limitation? Is it a physical or mental impairment that substantially limits a major life activity? Maybe. I would go so far as to say probably. But we do have some guidance on whether or not someone with that type of impairment would qualify under 504. And the guidance that we have comes from those 2008 ADA regulations that I mentioned. So temporary disabilities count as a disability if they are expected to last for 6 months or more. You don't have to wait the 6 months to see if it lasts for 6 months, right? Because it's if it's expected to last for 6 months or more. So you can make that determination up front. So, there's a case in your materials about broken arms and legs. A typical break is going to heal. They're going to recover within that 6-month time frame. So typically, a routine broken bone is not going to be a disability that qualifies somebody for protection under 504 because the expected duration is not going to be long enough to make that person fall into the category of an individual with a disability. One example of a temporary condition that comes up a lot is concussions. So that's another one that you should be thinking about and be mindful of. It's hard to tell how long a concussion is going to last, right? And oftentimes, a concussion is something that's going to last longer than 6 months. So even though something is temporary up front and you want to make that determination, is it expected to lie as a disability? And you have that continuing child find obligation. So you're going to want to monitor students with concussions over that time period to see how that condition is evolving, developing, continuing to determine whether or not that might qualify them as an individual with a disability. So a temporary impairment could turn into, an impairment that qualifies a student under 504. So just be aware of that too. Okay, on the next slide, is the impairment a substantial limitation of a major life activity? So let's talk about that. Be aware, be mindful of an ongoing obligation to monitor when you have a condition that you expect to be temporary, like a condition, and be mindful of your ongoing child find obligation, because as you know, as the condition develops or as time progresses, if you determine that this may be something that's going to last longer than 6 months, it might be, it might be something that's going to qualify the individual later. If you have a student who presents with a gluten intolerance, the student does not have celiac disease. They just have an intolerance to gluten and they don't do well when they consume gluten. We can agree that's an impairment, but if there are no issues with that child at school, no limitations in the educational setting, that's probably not going to be a substantial limitation. It's an impairment, but it's not a substantial limitation. Now, the analysis would be different if, because of the effects of that gluten intolerance, the child is not, not attending school, they're missing instruction, or, if they have these routine absences because of their gluten intolerance, then that might be a substantial limitation. But if you've got a student who has a gluten intolerance and they don't consume gluten, then they're not going to be considered a substantial limitation. But just remember, again, it's case by case. You have to look at the facts, look at how the impairment is manifesting, and then make a judgment. But we don't have any real definitions of what is a substantial limitation. Now, on the other hand, we do have definitions of what constitutes a major life activity. And there's a list in your handout that describes this, what a major life activity is. But of course, like anything, when there's a list in our materials, just know that it's not exhaustive. Those are things that would qualify as a major life activity, but there could be other things that qualify that aren't listed there. Lawyers never give you an exhaustive list. So you can see, though, it is extensive. There's a lot on there. So just about everything we do from day to day is a major life activity. So the things that you do to care for yourself, performing manual tasks, seeing, hearing, eating, sleeping, walking, all of those things are major life activities. But if you look at the right-hand column, you'll see we have some activities that we put in bold because they're things that you see in your buildings as educators every day. Learning, reading, talking, thinking, and communicating. All of those things are listed in the ADA as major life activities. And so those are things your students are doing all the time. And those were added to the definition of major life activity in 2008. So that was one of the areas that was expanded by the amendment in 2008. So other expansions in 2008, a major life activity now includes the operation of a major bodily function. So that pulls in things like celiac disease that I mentioned, Crohn's disease, cancer, other long-term illnesses. It's very clear under the amendment that those are the kinds of things that are also considered major life activities. So on the next slide, another area that was expanded in 2008 was what is a substantial limitation. And like I've already said, I can't give you a definition. But I can tell you that what you cannot do when you're evaluating whether something is a substantial limitation is consider what we call mitigating measures. So that's one of the major changes from 2008. You can't consider a student in what we call their mitigated state. In their seat, they're able to attend to their work. You evaluate them and you're not seeing the effects of this ADHD. So mitigating measures. So what we get from the 2008 regulations is that you can't look at mitigating measures when you're evaluating whether or not a student has whether something is a substantial limitation. You have to look at them in their unmitigated state. So one of the examples that we like to give is ADHD, because oftentimes, when you've got a student with ADHD, they're on medication. And when they're on medication, they can concentrate and they can sit still and they can complete their work and they can focus. So, when the parent comes in and says, hey, my child has ADHD, I think they need to be evaluated for a 504, and you don't see that there is anything that it's having an effect in the educational setting. But in order to determine whether they qualify as an individual with a disability under the updated regulations, you have to look at them in their unmitigated state. And, so you have to look at, what does the student look like without their ADHD medication? So sometimes when we tell clients that, the answer we get is, we don't know. We don't ever see the student in their unmitigated state. But our response back is that you probably have someone in your district, from prior to the child's diagnosis. There's probably somebody who can tell you what this child was like before they started taking this ADHD medication. And if not, the parent can certainly tell you what their child looks like in their unmitigated state. And that's the information that you need to determine that. And, the reason for this change, like I said earlier, the 2008 ADA amendments came about because, Congress did not feel that this was being interpreted in a way that protected the broad scope of people the law is intended to protect. So this was an expansion of that coverage to expand the scope of individuals entitled to protection. So there is an ADA case out of the Supreme Court about an employee with carpal tunnel syndrome. And this is an employment case. This is an ADA case. It's not a 504 case, but it's interpreted, like I said, the same way. So this was a manufacturing employee who was able to work on the line with his carpal tunnel when he was wearing his brace. And he claimed that he was an individual with a disability, carpal tunnel, substantial limitation of a major life activity, physical impairment, that he was being discriminated against because of his disability. And the trial court said, you can do your job, so you're not substantially limited. And that was true while he was wearing that brace. But the US Supreme Court said, you have to look at this individual in his unmitigated state without the brace to determine whether he's substantially limited. And in this case, without the brace, if he's substantially limited, then he is entitled to ADA protections. So that means he can't be discriminated against on the basis of that disability. So, that's how we got here. That's when Congress expanded the scope to say that, the trial court got it wrong, the Supreme Court got it right. This is an anti-discrimination act, and you should be reading it really broadly. So that's one of the ways the scope got expanded. So we know we can't consider children in their mitigated state either when we're determining whether they're entitled to protections under 504. So what are mitigating measures? So again, there's a non-exhaustive list in your handout, and it includes things like medication, hearing aids, the use of assistive technology, and what you'll see most often are the last two: reasonable accommodations and learned behavior or adaptive neurological modifications. So I've got an example about that one as well. So shortly after the 2008 ADA amendments, there was a district who had a student who asked for 504 accommodations. They wanted extended time on the ACT, and this child was a junior in high school, ranked in the top 10 in his class. So obviously very successful academically, doing very well. And the district said, you are not an individual with a disability, and we are not going to, we're not going to give you a 504 plan. And the family took that to OCR. And they had a letter from the American Institute of Dyslexia that said that their son had dyslexia. And despite the fact that he's doing very well, he had that medical diagnosis. And the district said, yeah, maybe so, but we are not seeing the effects of that. He doesn't need extended time on the ACT. He's doing great. So OCR said, but you looked at him in his mitigated state. Now, this isn't an example of a child with ADHD on medication. This is an example of someone with dyslexia. And what OCR said, though, is that if he has dyslexia, which we know he does because he has a medical diagnosis, and he's gotten as far as he has and been as successful as he is, he's probably learned how to do things like how to chunk or how to context clue read. And all of those things are things you would teach him anyway, right? As a student with dyslexia, those are learned behavior modifications. And so when you look at him in his mitigated state of, using those learned behavior modifications,
then you're not looking at him in his unmitigated state, basically, is what they said. And they said you can't look at him that way to determine whether he qualifies. So you have to go back and reevaluate that student. So I'm going to come back to that student later when we talk about some other issues, but that's just an example of how mitigating measures factor into the analysis. Another change to the 2008 regulations is episodic impairments. They're like temporary impairments, but they're recurring. So something like a seizure disorder, it could be migraines, but something that comes and goes. If something is recurring, you have to look at it as whether the disease or the condition substantially limits a major life activity while it is active. So it doesn't have to be, it doesn't have to be the entire 6-month period. We don't look at it as temporary because the periodic recurrence is going to happen over longer than 6 months. It doesn't have to be constant. So you're looking at whether when that condition is active, it substantially limits a major life activity. On the next slide, Maya, can you go to the next slide? Thank you. So there is good guidance also from the 2008 regulations, though, about the use of drugs and alcohol in a public school setting. This is really helpful guidance, and I'm not going to go into a great deal of detail, but just be aware that there is guidance that exists on this point, and the guidance essentially says people in recovery qualify for protections, but individuals who are actively using are not in active recovery, and so they do not have the protections of the Act. So we also have very clear language that agencies may take disciplinary action for the use of drugs and alcohol, even when the individual is in addiction. So its current use is not going to be protected, but someone in recovery would be protected. Okay, so let's move on and talk about evaluations. So how do we determine whether someone is an individual with a disability? How do we evaluate that student? So anyone can refer a student. It can be a parent, it can be a teacher, it can be a counselor, and it can be the student, it can be anyone. If you have a process that you follow, a form that you like people to fill out, if you have, something in your board docs that has, referral forms, just be aware those forms can be used, but you cannot require the referral to be made on a specific form. If you get a referral, you have a referral. If it's not on the form you like, then the person who receives the referral can certainly reduce it to writing on that form. But just know that you can't let your process be a barrier to the referral. So once you have a referral, you've got the evaluation requirement. You do have to do an evaluation before you develop a plan. You can't write a plan without evaluating. You also can't delay an evaluation under 504 because of another process. So RTI, ELL services, those kinds of things, you can be doing those at the same time, but you can't require those processes as a prerequisite to conducting your 504 evaluation. And when you get a complaint with OCR, the very first thing they're going to ask you for is the 504 evaluation and the plan, if there is one. So if you did a plan without the evaluation, OCR is going to ding you right away because you're out of compliance. There's, no way to get past that first document request. So the evaluation, of course, is going to be critical. So what does that look like? Well, an evaluation under 504 does not look anything like an evaluation under the IDEA. Evaluations, under the IDEA are complicated procedures, but under 504, it's simply a group of persons knowledgeable about the student who are going to sit down and discuss the information that they have. It may include testing. It may not include testing. It's probably I'd say it will include information, a review of information the parent has provided. You don't have to agree with the information the parent has provided, but you certainly have to consider it. But there's no requirement of some, properly constituted team. That is not part of the 504 process. So if you're talking about a diabetic student, you may just need the parent and a nurse, maybe the student, but you're not going to need, a large group of people for some of these situations, for some of these evaluations. So on the next slide, you do have to have consent to evaluate. OCR has said that consent is required. Usually your 504, evaluation planning form, it'll say the parent is consenting, and you're going to have the parent sign that form. So you do need to have consent. So on the next slide, when do you evaluate? So there's nothing in the 504 regulations about the specific timing. Nothing that says you have to do a triennial review like you do under the IDEA. That is not so in 504. Now, that does not mean, though, that your board policy doesn't have that type of requirement. A lot of board policies have 504 evaluation requirements that align with IDEA requirements. So you may have a board policy that says you have to do a triennial review, but if you do, that's coming from your own internal policy, not from the law. So you do need to know your procedures. But under the legal requirements, there are 3 times when you are required to evaluate under 504. And first is, of course, you have to do an initial evaluation, as I mentioned. You have to evaluate before a significant change in placement, and then when conditions warrant. So that's a catch-all. That means, what we interpret it to mean. It means what you decide it means. It might be when a child transitions to a new building. That's usually a time when an evaluation would be warranted. It might be every year, it might be every 3 years, and certainly your board policy may say that, but it's up to you. But if you see a change in a student in the way they're functioning, that's when conditions may warrant. So it doesn't necessarily have to be on a specific timeline. You should just always be on the lookout as you're monitoring these students to see if there are changes that may require reevaluation under 504 to address their needs. But other than that, there's nothing in the law about when you have to evaluate. You want to do it, in a reasonable time frame when these triggers occur. So initially, significant change in placement, or when other conditions warrant. So on the next slide, once you've found these students, you've evaluated them, what do you do next? Well, a group of persons knowledgeable about the student, the meaning of the data collected, and the placement options are going to review the data and have a meeting. That's how the 504 meeting is going to go. Do you need a general educator, special educator, a person who can interpret the results, and a district rep? No. Nothing in 504 requires that same IEP team concept. So it's just not as complicated. But the group of people who are knowledgeable, who have the information and are able to understand and interpret the data, are going to get together at the table, and they're going to decide 2 things. 1, whether they qualify as a student with a disability under 504. And 2, if so, whether they require the provision of regular education or special education and related aids and services to meet their individual needs as adequately as the needs of non-handicapped students are met. So if the student is eligible, you're probably going to write a plan. And if the student is not eligible, you are probably not going to write a plan. But either way, at this point in the process, you're going to give the parent notice of procedural safeguards. So one way or another, this is where you tell them, here is what we decided. Here is a copy of your rights under 504. And if you disagree with us, this is how you sue us or file a complaint against us. So you do have to give them their procedural safeguards at that point. That is a requirement. So one question that we often get, and something we often see after 504 complaints are being investigated, a lot of districts use software that has prior written notice forms for 504 students that they use, not for students on an IEP, but for students with a 504. Just be aware that that is not a requirement. There's nothing in the law that requires you to use, to give the information with the 5 sections on that form about, what the decision was and why and what else was considered. All of those things on a prior written notice for under the IDEA, those are not required under 504, and we don't really recommend that you use those forms for 504 because it's confusing. It makes parents think they have an IEP. It gives them information that you don't have to go through. The requirement under 504 is that you give them notice of the decision on this date we met. we reviewed this, this is our decision, and here are your procedural safeguards. Yes, you do have to give them procedural safeguards. I just saw a question pop up, a specific notice in 504. I believe there is a specific notice form, but I'd have to get back to you on that because I am not positive where to locate that form. Okay, so the next slide, let's talk about writing the plan. Oh, thank you. Somebody just answered the question that there's a procedural safeguards for 504 in board docs. Okay, so your placement has to provide FAPE in the student's LRE. So there is an LRE requirement under 504. It means the same thing under 504 as it means under the IDEA. This is one of the ways that the two laws are the same. So to the maximum extent appropriate, students who are being served under a 504 plan shall be educated with their non-disabled peers. And there is also a FAPE requirement. The child must receive a free and appropriate public education, and that is defined as the provision of regular or special education and related services, related aids and services that are designed to meet the individual educational needs of students with disabilities as adequately as the needs of students without disabilities are met. So one thing on that, and this, we always get questions on this too, and it does get a little bit confusing, and I don't have a great example, but just notice that it doesn't say that you're going to give the student accommodations. It says regular or special education and related aids and services. And it's, you know, individualized, and it's to meet their needs as adequately as the needs of non-disabled students. So people tend to think that 504 is for accommodations only, and that's not necessarily correct. FAPE for 504 purposes can include special education and related aids and services. If you have a student with a disability under 504 who does not meet the specific criteria under the IDEA's eligibility categories, that student may still require special education and related services, and it can go on a 504 plan. So just be aware that can happen. The definition of FAPE allows special education to go on a 504 plan. It's right in the definition. So, you know, as I said, very often people think 504 plans are accommodations only. So, you know, a 504, the law requires you to make what you have accessible to your students. So that may include some special education, but it's a local decision. Many districts will start with an IDEA evaluation first because they've made the decision that if the child is going to have special education and related services, then the district is going to pull funding for that child, and you're going to program, you know, if you're going to program for that. So, you know, you're going to do the full blown IDEA evaluation, but just know that you can put special education on a 504. Like I said, we don't see it very often, but it certainly can happen. All right, so on the next slide, accommodations have to be reasonable. That's the scope. You don't have to provide an accommodation that isn't reasonable. So, you know, the question, what is a reasonable accommodation? How far do I have to go? Where do you draw the line in an alteration? And the answer to that is when you fundamentally alter the program. That's when we're no longer in a reasonable accommodation. So for example, you know, how much time is extended time? You know, how much extended time is too much time before it fundamentally alters your program? This is really something to consider with twice exceptional students. It comes up a lot with twice exceptional. So like, you know, for example, you've got a child with ADHD and anxiety, but they're also gifted and they're in accelerated classes. But the student has a 504 plan that says they only need to complete 75% of the reading or 75% of the work. You know, you may hear pushback from teachers. We have clients who tell us that they get pushback from the teachers of these accelerated classes who say, you know, once you reduce the workload to 75%, that's not really an AP class anymore. That's a general level class. And so, you know, I don't think the student should receive this accommodation in my class. So that's a little bit, you know, that's where the rub comes in, because you can't condition a student's receipt of your services, that AP class, on them forfeiting their right to accommodations that are in their 504 plan. So you have to make reasonable accommodations. But at what point does it become a fundamental alteration? So, it's a case by case basis. If their 504 plan says they only have to do 50% of the work, maybe in the AP class, it's that they only have to do 75% of the work. I mean, some sort of of accommodation is still going to be appropriate, but you have to decide based on the facts at what point does that become a fundamental alteration, and make the decision based on those facts and circumstances. There's not a bright line test, but there is the ability to, while they're entitled to their accommodation across all settings, if there's a particular setting where that accommodation results in a fundamental alteration of the program, then you can talk about how you're going to, maybe reduce that accommodation for that one class. So just be aware of that. All right, on the next slide, so just remember, this is an anti-discrimination statute, as I said at the beginning, and it says you're going to make all of your programming accessible. We aren't going to make our programming inaccessible to students with disabilities. So if you look at the slide, you can see what I'm getting at. This does mean all programming, including sports programs, including field trips. And this frequently comes as a surprise to coaches. Again, I don't know if you deal with this in your districts, but I often see it when we have coaches who are not otherwise educators, coaches who are people activity contract, coaches who aren't teachers. Sometimes this comes as a shock to them. They don't realize that they are also required to provide whatever accommodations are on that child's 504 in the extracurricular activities. Sometimes it's not that the coach, doesn't recognize that they have that obligation. I also see sometimes coaches aren't aware of what that child's disability is. They aren't informed. I don't know why. I see this with substitutes too. Sometimes I have districts say, oh yeah, no, we didn't provide the 504, and it applies to the IEP as well. We didn't provide the IEP to the coach because, FERPA. So just, keep in mind that a coach has a legitimate educational interest in the records related to the child's disability so that they can make the program accessible. It's their legal obligation. So don't be wary of sharing 504 information with coaches. So we've got another example. A student that had extended time on their 504 plan was trying out for the cheerleading squad. And the cheerleading coach did not give her extended time to learn the cheers. And in that case, I don't know if the cheerleading advisor didn't know or just said, no, I'm not doing it. I'm not sure in this case. But for whatever reason, the student was not given the extended time. And then she got cut from the cheerleading squad. She didn't make the team. So when the student challenged that, they filed a complaint with OCR, and they said, I didn't get my extended time to learn the cheers. And so I was denied access to this athletic program because I wasn't given my accommodation. And OCR said that was a violation. So, be aware that what's on a 504 applies across your program. And like I said, if it results in a fundamental alteration, the 504 may need to say, in this context, they get this accommodation, and in a different context, they get a different accommodation. So it needs to be individualized, but just be aware that that does apply across the program. They have an auditory processing disorder. And because of this auditory processing disorder, maybe they need a different method of cueing or instruction from a coach. There could be a lot of reasons why you would need to modify how you're instructing or how you're working with a student in an extracurricular activity as well. Okay, on the next slide, procedural safeguards. So you do have a requirement, as we said, to notify parents of these decisions and to tell them how to challenge it. We call it the Here's How You Sue Us notice. It has to be provided to parents in their native language. And of course, that there's case law on that, but that's common sense. If you don't inform the parents in their native language and they can't understand it, that's not really notice. So you do have to provide that in their native language. Now, under 504, there are a lot of different ways to challenge a district's decisions, and how the challenge is brought forth really is somewhat dependent on the nature of the dispute. So again, remember, this is an anti-discrimination law, which means that districts have an obligation to protect against discrimination on the basis of disability, and that includes discriminatory harassment. If a student is harassed on the basis of their disability, that is discriminatory differently or harassed because they're disabled. And this is true of any protected class. That's, that's what we see in Title IX. If a student is subjected to sexual harassment, that's sex discrimination. And it's the same with a disability. So you are required to have a grievance procedure in your board policy to address complaints of disability-based discrimination. Your policy should have at least one person designated as the compliance officer for 504. And that's who should be presented with any grievance about disability discrimination. And the law requires that you have a procedure with appropriate elements of due process and that you must be prompt and equitable. That's it. That's the requirement. So there's not this, really specific regulatory process you have to follow like you do with sex discrimination, with sexual harassment. But under 504, you do have to have a process. Students are entitled to due process, and you have to deal with it promptly and you have to be equitable. Now, make sure you know who your 504 compliance officer is. It's really important to know who they are. It might be you. Hopefully, if it is you, you do know that you're that person. Although I have been in presentations where people learned for the first time that they were the compliance officer. So it wouldn't be the first time. So if you don't know who that is, I strongly suggest that you look it up and find out in your board policy. And of course, once there is a finding of discriminatory harassment, the job of the district is to stop the harassment, prevent its reoccurrence, and eliminate any hostile environment. So when there are disputes related to not harassment, but identification, evaluation, or educational placement, they can take you to due process. It rarely happens, but if you find yourself in that situation, you are required to find a hearing officer, usually from DEW. You pay for that. You have an administrative hearing, like a mini trial, where people testify under oath, they're cross-examined, there's a transcript, and then the hearing officer issues a decision. So there can be a due process hearing, but those are limited to identification, evaluation, and placement. If it's a harassment complaint, it's going to go through your board grievance policy. And then they can file a complaint with OCR. That's a dispute resolution mechanism that's always available to students. And then, of course, they can sue the district in court. So those are the ways that those decisions can be challenged. And in your procedural safeguards notice, that is how that will be presented to the parents, so they have that notice of what their rights are. So what do we do to avoid that? On the next slide, you want to avoid the complaint in the first place. You want to be proactive. That's probably the best takeaway from this presentation that I can give you, is do everything you can to avoid those complaints in the first place, because a lot of times they come down to, to things like training and communication. So, get trained on your legal compliance, and we're doing that today, so that's good. Make sure your staff have access to your policies, know what your policies are, train them. Some gen ed teachers, legitimately don't know their obligations to students with disabilities. It's true. I see it over and over. Repeated training and reinforcement of those concepts with your staff is going to be really crucial. Document compliance with policies. Documentation is always your friend. Show your work. You do good work, make sure you write it down, make sure you document it, however you do. If you create a list of things that you're doing with dates, or if you follow up on things with emails, anytime you put things in writing, it's going to be helpful to defend against a challenge. Make sure staff members know who they can call for help, who that 504 compliance officer is, or who they should reach out to. Staff training on good communication and conflict resolution. I can't emphasize that enough. Communicating effectively with parents, learning how to work out disagreements before they escalate to the level of complaints, that is so important. Parents, they want to feel heard. And, I see this time and time again, a parent is explaining what the issues are, and districts are responding to that behind the scenes. They may be doing work to try to figure things out, and it takes time, but they don't communicate what they're doing with the family, and the family feels ignored. So communication is so important. They want to know that their child's needs are being addressed. So it's important to communicate with them and show them what you're doing. Another tip is to pay attention when you see something changing. When parents start to change their tone, or when they change their mode of communication, if they were just dropping by, having informal conversations, and then all of a sudden you're getting really formal emails. It might be because those emails, it might be because they're getting advice behind the scenes. It might be that a lawyer is ghostwriting those emails. I mean, if you get an email from the parent that definitely does not look like the grammatical structure or tone that they would normally use in a written communication, probably someone else wrote the email, a lawyer or an advocate. If a parent starts asking to make recordings of meetings, or if they start making records requests, if they start complaining about staff, just, again, this is probably common sense, but it means there's something brewing. There very well could be something brewing that you want to try to head off at the pass, see if you can get it resolved before it's too late. Try to be proactive there. And then big red flags. If you get complaints that the child isn't receiving the services under their plan, if they start bringing that advocate or bringing the attorney to meetings, if they start requesting private placements, once they start talking about IEEs, those are signs that things might be escalating. All right, so that is the nuts and bolts of 504. We're going to take a break, and then when we come back, we're going to talk about some of the common questions we get in our office about 504. It's 10:07. We're running a little bit behind, so why don't we go until, let's do 5 minutes. So let's come back at about 10:12, and then we'll talk about the questions we get in our office. So I'll see you in 5 minutes. Okay, I'm back. I've got 10:12. I don't want to jinx us, but I've been told that the connectivity issue is resolved. So hopefully we can keep on trucking. So thank you all for your patience. Okay, so we are going to do some FAQs. And the first one is up on the slide already. If a student is not eligible under the IDEA, might they still be disabled under 504? And the answer, of course, is maybe. So on the next slide, if you look at that yellow circle in the middle, those are students who qualify under the IDEA, right? Such specific criteria to qualify under the IDEA. A student with a disabling condition as defined in the IDEA that causes an adverse effect on their educational performance, but needs special education. So the blue circle is the 504 circle. That's bigger. It includes every student with a physical or mental impairment that substantially limits a major life activity. It's much, much broader. So if a student doesn't fall in the center circle under the IDEA, they very well may fall in the larger, blue circle. But keep in mind that when we're talking about an individual with a disability, remember again, and I know I sound like a broken record, but it's an anti-discrimination statute. And remember that it borrows from the ADA. So nowhere in the law does it say child or student. So the protections, the anti-discrimination protections under 504 apply not only to students, but to the adults that work for us, to our employees, to visitors, to our campuses. It's about accessibility. That's what 504 is about. So because you are a recipient of federal funds, you have to make your programming accessible to your students, but also to your employees and your visitors. So that's why, you put on a school play, you have an interpreter, because a member of the public, who is hearing impaired wants to access your federally funded program. It's very broad coverage. Anyone who has been in schools for a long time knows that 504 is a lot bigger than it was 15 years ago. And the reason for that is because of the expansion of the regulations, because of the ADA amendments of 2008 and the expansion of the way we're reading it, because that's the way it's designed. It's, it's an anti-discrimination statute. All right, next question. Next slide, there we go. Do we need a medical diagnosis to establish an impairment? I had a client ask me this last week. Do we need a medical diagnosis? So, you may recall that earlier in this series, I think it might have been the first session in this series, we talk about the difference between a disability and a diagnosis. Whether or not a disability, which we call the big D, and a diagnosis, which is the little d, whether or not you need that diagnosis to establish an impairment. So on the next slide is your answer, and the answer is no. You don't assume a medical diagnosis is required. Nothing in the law requires a medical diagnosis. So if you truly believe that you need a medical diagnosis for you to reach your determination, you can ask for one. But remember, of course, it's a free and appropriate public education, keyword there being free. So if you believe you need a medical diagnosis for a particular kid, you can obtain it at the school district's expense and with the parent's consent. So you can't require the parent to provide it. You can't require the parent to pay for it. And in most cases, you probably don't really need it. But if the parent refuses consent for you to obtain a diagnosis, then you have to rely on whatever information you do have. You're going to document that request for consent and the lack of consent, especially in a situation where you really feel like you don't understand the disability without, some guidance from a medical professional. Always document that the parent refused to give consent. And so you relied only on the information that you had. You may have a situation where you end up deciding the child is not eligible, and maybe a medical diagnosis would have changed that conclusion if you had it, but you don't. Or, maybe even just a consult with their provider may have changed things. So it's going to be important if you have to defend your decision that the child does not qualify. And if that's the case, then you need to document that. But let's say, for example, you've got a student who's suspected of having ADHD. So a child who you think is not concentrating, but you don't have a diagnosis. So the data that you might have, you've got records of the child's behavior, you've got aptitude and achievement tests, you've got their academic performance. If they take medication at school, you have records of what that medication is, right? So if the school nurse is administering medication to that child on a daily basis, then you're going to have those records. You've got disciplinary records, and you've got reports from teachers who have observed this child. So you probably have quite a bit of information that you could look at in order to determine whether you have a student with an impairment substantially limiting the major life activities of thinking or concentrating. So you probably have what you need without a medical diagnosis. So don't get too hung up on that if the parent does, refuse, or if they just don't have one. And again, it may be a situation where you don't need it. If you've got a child exhibiting the textbook, indicators of ADHD, you really probably don't need to have a medical diagnosis. I mean, your job is not to diagnose kids. Your job is to make your program accessible. And so if you see things that are manifesting in the educational environment, if you've got a medical diagnosis, great. But if you don't, when in doubt, you do your evaluation and you rely on whatever information you have available to you. So on the next slide, to put this in perspective, there is a Dear Colleague letter that we talked about earlier that I want to get into a little bit about ADHD specifically. So this is a guidance letter from OCR, and this is one from, let's see, it's dated on there, July of 2016. It's a really long letter. It's got a lot of good information in it. Honestly, it's worth a read. This letter was aimed at school districts, and it's specifically on the issue of identifying students with ADHD under 504. That's the focus of this lengthy guidance letter. And OCR reached the conclusion that this is a very large population of students being overlooked. They basically said school districts are failing this population of students because they are not identifying these kids. And this letter is about the failure to identify and evaluate students who may need accommodation because of ADHD. And it gives us a lot of information. But one of the things that it said is that the district staff are the eyes and ears of the district for child find purposes. And teachers who are working with our kids may notice the kinds of things which could suggest that a student might have an ADHD related disability, like restlessness, inattentiveness, that's, inappropriate for the child's age, trouble organizing tasks and activities. Someone just asked for a link to this letter in the chat. I can try to find that. Oh, good. Somebody already gave a thumbs up. Yeah, if you Google it, it should pop right up, but it's the, put the date and the Dear Colleague letter in the search. So, the kinds of things that might be observed, rushing, difficulty starting tasks and transitioning from task to task, being organized, recalling information, producing messy work with careless mistakes, difficulty completing assignments, all of those kinds of things. That's what teachers, if they notice that, that could suggest that the student might have ADHD. Now, I don't know about you. That does sound like a lot of kids I know. And also, I don't know about you, but I think that that may have increased a bit since this Dear Colleague letter came out in 2016, once we've gotten through the pandemic and seen some changes in student behavior after that. But what they said is that you better be paying attention. That's literally, well, maybe not literally, but that's essentially what it said, is that you need to be paying attention. These things you're observing may be telling you that you have a child find issue and an obligation to program for these children. And they went on to say that while a medical diagnosis may not be required, again, because we aren't diagnosing kids and we can't force the parent to provide a diagnosis, OCR will presume that unless there is evidence to the contrary, a student with a diagnosis of ADHD is substantially limited in one or more major life activities. So it's kind of it's a presumption. You have to overcome the presumption. So what they're saying is if a parent shows up with a medical diagnosis of ADHD and says, my kid has ADHD, here's the proof, OCR will presume that that student qualifies as an individual with a disability entitled to protections under 504, unless you have evidence that overcomes that, presumption. So you're still not required to have a diagnosis, but if you have one, that student qualifies unless you can prove otherwise. That's essentially what's happening here. So if you know a student has an ADHD diagnosis, it's presumed, and then we're done unless you have evidence to the contrary. So what kind of evidence to the contrary would you have if you don't think this student with the diagnosis would qualify? You would have to have evidence that the student is able to concentrate in a distracting environment. They're performing well. Their homework is neat. They're turning things in on time, that kind of evidence. And if you don't have it, OCR is going to presume they qualify, which means that, they qualify. So then you have to evaluate whether they need services to accommodate that. But OCR did also say you do not need a medical diagnosis. So the takeaway is that you can't use the academic success, those mitigating measures, to conclude that a student is not substantially impaired. Because like we talked about the student earlier, someone with ADHD, the other student was the dyslexia student, but someone with ADHD may achieve a high level of success, but may nevertheless be limited in a major life activity due to their impairment because of the additional time and effort they have to spend to achieve that success. They're getting all A's, but it's taking them 8 hours to do their homework, and their peers are only taking 2 hours to do their homework. A parent may be telling you, my child is so stressed out. And they're using mitigating measures if they tell you that, because it's taking them 8 hours and it's making them so stressed. But they're doing something more to compensate for their disability. That's what the student is doing on their own. So just be aware of these arguments. Like I said, the letter really is probably worth a read. It is a little long, but it's a good letter. And it's summarized in materials. So on the next slide, did I really mean it when I told you can never consider mitigating measures? So the answer to this is I meant it, but only sort of. So go back to the student we talked about earlier with the dyslexia diagnosis. He was, top 10 in his class, doing well, and wanted extended time. And the district didn't evaluate him. And as I told you, OCR said, nope, you looked at him in his mitigated state. You got this wrong. You need to evaluate this child. So the district said, okay, we are going to go back and evaluate him. We're going to consider him in his unmitigated state. And he qualifies as an individual with a physical or mental impairment that substantially limits a major life activity. He's entitled to protections. But any accommodation we would have given him, he already had. And that's why he was able to be so successful. So he didn't need anything. So while he qualifies as an individual with a disability, the district did not write a plan because they determined that he did not need plan. So the answer, and I think it's on the next slide. Is it on the next slide? Yeah. So you can consider mitigating measures when you're determining whether they need services, but you cannot consider mitigating measures when determining whether they're disabled. So when you decide whether or not someone qualifies as an individual with a disability, you have to look at them in their unmitigated state. But when you're determining what they need, you can consider them in their mitigated state, because their own mitigated state is the accommodation already. They don't need an accommodation if they've already, if they're already employing those kinds of, context clues and chunking that you would be teaching them otherwise. Okay, so what do you do with a child like that if they are qualified but they don't need accommodations? Well, there's language from the Dear Colleague letters we have on this issue too. I think there is a cite to it on page 12 of your materials. It's from OCR's Q&A that was published in 2012. And it says, although school districts may no longer consider the effects of mitigating measures when making a disability determination, so whether the student is disabled, they remain relevant in evaluating the need of a student with a disability for special education and related services. So not when determining whether they're disabled, yes, when determining the need for services. So you can, that's when you can consider it. So even though they're protected from discrimination because they qualify as an individual with a disability, they may not need special education related services or accommodations. Okay, on the next slide. So if the student doesn't need services or accommodations, what responsibilities do we have? So what do you do? What are your responsibilities to a student who qualifies but doesn't need services? On the next slide, you provide notice of procedural safeguards. You say, we evaluated you, we determined that you are an individual with a disability, but you do not need services, so we are not writing a 504 plan. Here is the notice of procedural safeguards, but you provide no services and you write no plan. You don't write a plan just because they qualify. They need, they have to need the accommodation and related services on the plan. Otherwise, we're not gonna write a plan. Okay. Next question we get every year, multiple times, usually in about February and March, this question starts to roll in. Do we have to send a medical attendant on the spring break trip if we're, sending our 8th graders to DC? Do I really have to send a medical attendant? So the answer is maybe. On the next slide, parent participation, excluding a student, providing equal notice. So let's talk about those concepts. So maybe, this is a statute about access. So if the child needs a medical aid to access our district sponsored program, that aid is going on the trip. If they need that aid to access the program, they get to go. We can't deny them the benefits of or participation in our programs that are supported by federal funding on the basis of disability. So then the special ed director gets the superintendent on the line, and the superintendent says, I don't want to pay for that. How am I supposed to pay for that? It's really expensive, right? And I get it. But when they're looking at whether something is reasonable, they're looking at the cost in relation to your entire district budget, not the cost of this particular trip. So cost is usually not going to be a good enough reason to make it not a reasonable accommodation. So the next question we get is, can we make the parent go? Once we tell them, yes, you have to send somebody who can attend to this child's medical needs. Can you make the parent go? The answer to that, of course, is no. You can only require a parent to go if you're requiring all of the parents of all of the gen ed kids to go to. So you can't require a parent to go on the trip just because their student is disabled, because that is discrimination. Can you ask a parent to go? Absolutely. And, sometimes that is the perfect solution. A lot of times the parent wants to go. And if you say, hey, maybe you could go, and then we can make sure your child's needs are addressed on the trip. And the parent says, absolutely, sure. Let me do that. That would be fantastic. Sometimes the kid thinks, I don't really want my mom or dad to go. But the bottom line is you can ask the parent, but you cannot require it. Next question we get about that is, do we have to pay the parent to go? I mean, well, you'd have to pay someone else. So, covering the costs might be appropriate. Covering the cost of part of the trip might be appropriate. If you can get to a place where you have an agreement, get to a place where no one is arguing about what the child needs to make it accessible, try to compromise, try to work something out. If you have to pay for it, but you're not, paying the cost of having the attendant there in addition to the cost of paying the employment rate of pay for the attendant and have the parent providing the services, maybe the cost of the actual trip is going to save the district some money. So that might be a way to go if you can reach that compromise. So can you exclude a student on the basis of their disability if they have terrible behavior, or if they're medically fragile? Can you exclude them from participating in that overnight trip? So, I would caution against denying participation to a student with a disability. But that's not to say that there aren't legitimate reasons why you might need to exclude a student. Sometimes it happens. Now, for instance, if you've got a student who's been suspended or expelled, if you've told all the students across the board, non-disabled and disabled students, that this applies to everyone, you cannot go on this trip if you've been suspended or expelled, in this semester or in this grading period. If you've got a uniform policy that's consistent, that applies to everyone, that might be okay. If you have a GPA minimum requirement to go that applies to everyone, you must have a 2.5 GPA to go on this trip. Those are legitimate non-discriminatory reasons. But sometimes we're asked about excluding a child, because of their disability from certain activities based on the inherent risk or the danger of the activity. So, for example, if you've got a sport, a contact sport that you have concerns about because of the child's disability. So we have an example of a student who wanted to play basketball, but the student had been in a car accident and had a traumatic brain injury. This student wore a protective helmet, and in this case, the student actually wanted to play basketball without their protective helmet, and the superintendent had legitimate concerns about that. This student was supposed to be wearing a helmet, and they not only wanted to play basketball, they wanted to play it without their helmet. And the parent agreed with the child and said, yeah, it's fine. I don't want them to wear a helmet to play basketball. It'd be really hard to play basketball in a helmet. So what do you do in a situation like that? This is where you're going to want to get the best medical information you possibly can. And if the parent doesn't sign a release, then, consult with your school nurse based on whatever you have, based on whatever you know. But in this particular case, the parent did sign a release, which, sometimes they do, sometimes they don't, but the parent did sign the release. The district got to talk to the doctor, and the doctor said, I would never allow this child to play a contact sport without their helmet. And not only that, I wouldn't let this child play a contact sport at all, even with their helmet, which was, of course, the superintendent's gut instinct in this case as well. The doctor completely agreed and said, no, I would never let this happen. So now the district has a legitimate medical reason to deny the child the opportunity to participate. And that is different. That the doctor is saying the child's participation presents an unacceptable risk to the student's health or safety. And that is the standard. When there is something that presents an unacceptable risk to the student's health or safety, then you can treat them differently. That's the standard. So, our advice in that situation is always to go get the best medical information you can on what the student's limitations are and make your decisions on a case-by-case basis. So another example, how about a student who's having seizures? They're not having seizures every day, but they are occasionally having seizures. We talked about, a seizure disorder as an episodic impairment. And there's a case in your materials about this too. This student was having, episodic seizures, and they had, of course, now you have to have your seizure action plan, right? But in this case, this was before that law. There were protocols put in place for the child's safety. And what their protocol said is that if the child has a seizure on the day of the field trip, they cannot go. And that was reasonable. The student was able to participate in 18 field trips that year when the medical condition was not an issue, when the student had not had a seizure on the day of the trip. Went on 18 field trips, but on the 19th field trip, the child had a seizure and the district said, no, you can't go. And in that case, it was really helpful to the outcome that the school had a protocol that they followed. You know, and it goes back to the standard of whether the child's participation poses that unacceptable risk to the student's health or safety. And the decisions have to be made on solid medical evidence and not assumptions. But in this case, you know, they had this you know, protocol in place for the safety, and they didn't routinely exclude the child from field trips because of their disability. They did it when they had, you know, when their medical condition was active and it posed that unacceptable risk. And like I said, helpful evidence that the student had gone on 18 other field trips that year. I have to say, I always scratch my head about this case because I can't imagine how there were 19 field trips in a school year. That seems like a lot, but that is what the case says. But in any case, that particular situation was determined to be reasonable, and that was not considered to be discriminatory. It was based on that unacceptable risk. All right, so let's see. On the next slide, let's talk about athletics. We've talked a little bit about this, but you know, we get that question. Does a student's 504 plan apply in the context of school athletics? And the answer to that, of course, is yes, absolutely. You learned a lot from our cheerleader earlier. We talked about the cheerleader who, you know, she gets extended time on her 504, and therefore she is also entitled to extended time to learn the cheers. We're going to apply that accommodation across all of our programming. And when she didn't get the extended time and she filed her complaint, OCR said, nope, you district, you messed up. You did not give her accommodations that she's entitled to, and that was discriminatory on the basis of her disability. So I told you I was going to come back and talk to you about her again. So I'm going to give you the rest of the story. The next year, she came back and she tried out for cheerleading again. By the time the complaint was resolved, of course, you know, football and basketball were already over. So she came back the next year in the fall and tried out, or in the summer, tried out for cheerleading. And this time they gave her extended time to learn the cheers. And, you know, we went back to the coach and said, this year you need to have a rubric that you follow when you are evaluating and selecting the students for your cheerleading squad. So give her the accommodations that she's entitled to, and then objectively evaluate, you know, everyone who tries out based on this objective criteria in a rubric to determine who is going to make the cut and who is not. And the second time around, she got her extended time. They did tryouts, and she still did not make the cheerleading squad. So this family filed a retaliation claim and said that this time they gave her accommodation, but the district retaliated against her because, you know, because of our prior complaint. And so they, you know, they've excluded her from the cheerleading squad in retaliation. And we said, okay, well, we knew this was coming, right? So we asked the coach for the rubric so that we would have our evidence that we gave her the accommodations. And then we applied this objective criteria, the same objective criteria we applied to every single student who tried out. And, you know, so let's gather this evidence. And the coach had thrown it all away. The rubrics were gone, the evidence was gone. So the takeaway here is, of course, you need to have legitimate non-discriminatory criteria when you're selecting students for extracurricular activities that are competitive to participate, but also don't throw your evidence away. In that case, the coach was able to, you know, sign an affidavit, you know, a sworn statement of what the process was and, you know, how the rubric was created, and kind of reconstructed it. And it was better than nothing. And it ended up, you know, okay. But just keep in mind that, you know, when you're going to have legitimate non-discriminatory criteria, that is your legal requirement. But when you need to be able to prove that, you know, you've got to have the evidence that you've done that. So show your work, as we always say, document what you do. So we talked a little bit about how a coach is going to know what accommodations a student is supposed to get. It's really important to have those discussions with your coaches. Pull the team rosters and pull the files for those kids. They should know what accommodations those children are entitled to. And as I said earlier, that there is a legitimate educational interest in this information so that they can make sure these children get equal access to your program. They need to know. So this is not a FERPA issue. They're only entitled to know what they need to know. But if a student is, is entitled to an accommodation, the coach has a legitimate educational interest in knowing that, because they apply across all settings. So again, we want to think about, though, what is reasonable. The accommodation, you're only required to provide accommodations that are reasonable, and you do not have to fundamentally alter the program. So, consider if you have a basketball player with a hearing impairment. They may need an interpreter to allow them to communicate with their coach and their peers. If you've got a student with migraines, they may need to be permitted to have an alternate tryout day if they suffer a migraine on the day of tryouts. So those are some examples. There's a case in your materials, I believe on the top of page 15, about a student with an emotional disturbance. And this student had in his IEP that he would be given frequent recueing, and that he would be permitted to line up last for activities. That was the accommodation. In this case, it was in I believe it was in an IEP. But in this case, there was the student played golf, and the golf coach refused to do it. They told the they told the coach. So it wasn't a situation here where they said, "Oh no, FERPA, we're not going to tell the coach," but they told the coach that these were the accommodations. And then the golf coach simply wouldn't do it and said it would be unfair to the other kids on the team if he got extra coaching, or if he let this student go last all the time. So the student filed a complaint with OCR, and OCR said, no, that's not a good excuse. The child is entitled to the extra coaching. The child is entitled to go last. And, anti-discrimination comes in the form of equity, right? It's not always that everything is equal. And so just because the child gets extra coaching, you can't look at that as unfair to the other kids. You're going to look at that as leveling the playing field. And that's what anti-discrimination is all about, providing them with equal access. And if that is what that child needs due to their emotional disturbance to be able to participate in the program, then you have to provide it in the golf, in the golf program too. So again, the takeaway: notify your coaches, make sure they know what's required, make sure they know they need to use non-discriminatory reasons for selection. And it's not automatic access. So, and I probably should have said that right up front. This doesn't mean that a student with a disability automatically gets to participate in your program. It means that they get to have the same access that their non-disabled peers have. And so, they can still be held to certain standards. That's why, as I said, if there's a, GPA requirement for something, you can apply that across the board. If a student with a disability wants to try out for the football team and they want to be the kicker, that's great. If they can perform, if they make the team, they still can be held to a competitive standard. It's not automatic access, but you do need to make the program accessible to them and accommodate them, a reasonable accommodation without going to the point of fundamental alteration of the program. So the last bullet on this slide, discussing accommodations, discuss them early, discuss them often, revisit that conversation when necessary. Is this accommodation working? Especially when you're talking, I feel like this comes up a lot in extracurriculars because, a 504 plan is going to be written based on what that child needs, in the setting that they're working on at that time. And then if they later join an extracurricular activity, there may be a new or different accommodation needed for that activity that wasn't really contemplated when the 504 plan was initially drafted. So, it's something that needs to be discussed. It's something that needs to be revisited, when necessary. So the next question we often get in our office is, hey, Bricker, can you give us a list of reasonable accommodations? And the answer to that, of course, is no. I wish we could. Wouldn't it be great if there was just like a menu and you could just pick and choose, what the child needs? But, accommodations are individualized. There are a lot of board policies and 504 forms that we see that have checklists, and those are super helpful. There's nothing wrong with having some ideas, something to spark, conversation or discussion about what the child needs. Some ideas to think about what might be helpful to a particular student. But it's not supposed to be, where the parent looks at the list and says, I want this and that, and I want that. The other thing we often see is, things like if a child has X disability, they're going to receive Y accommodation. We're going to follow this sort of rubric of if they have this, they get that. And again, that's not really how this process is supposed to work. It's an individualized discussion, and it's an individualized determination. So I can't give you a list. It can be anything. The real question is, how far do you have to go? And as I said, we've talked about this a lot with your twice exceptional students. But to understand what your obligations are really when determining what is a reasonable accommodation, that's another area where we look to the ADA. And under the ADA, the requirement is to have an interactive discussion and have this interactive discussion of what the student needs, and that's how you're going to determine what goes in that plan. So under the ADA, when an employee comes in and says, I need X because I'm disabled, the obligation for the employer is to sit down with that employee and say, okay, let's talk about this. How about this? We think this is reasonable. How would this work? And have this interactive conversation. That's what the ADA requires. And it's the same with your students. Have an interactive discussion. And again, if you've got those checklists or, those, kind of rubric forms of things that are often used for accommodations for specific situations, it can be a reference tool, but it should in no way be, the end all be all of what the determination is going to be for any student. So when I'm defending where we finally draw the line in offering an accommodation to a student, it's always helpful if we can say that we've made some accommodation, before we get to the point of saying accommodation is a fundamental alteration. So, what I mean by that is that if the extended time requested, if they've requested extended time for something and our response is no, extended time is going to be a fundamental alteration of the program, so we're not going to do that. It's really helpful if you are able to say when you're defending that kind of complaint, well, we didn't give them everything they asked for, but we gave them something. They requested 2 days of extra time, and we gave them 1 day of extra time. And again, as I said earlier, don't say no just because it's an accelerated class, an AP class or an IB, class. You don't have to give them the full amount of what they're requesting if that's not reasonable. What they're asking for may be reasonable. So sometimes they ask for something and you say, yes, that's not a fundamental alteration. But if you believe that it is a fundamental alteration of the nature of the program, it's helpful if you reach a compromise. When the requested accommodation, isn't given and it's challenged, that just makes it so much easier to defend. All right, so we've got an example about a case involving a high school swimmer. A young woman, high school age student, she joined the swim team, but she had a fear of drowning. We don't know why she joined the swim team, maybe an effort to overcome her fear. I don't really know what the situation was, but she wanted to be on the swim team despite that fear of drowning. And she needed to get in the pool, I guess, maybe to face her fear. So, but for whatever reason, she joins the high school swim team and she goes to the swim coach and she says, I need an accommodation. I need to be able to leave the pool when I'm having a panic attack, even if it's in the middle of a swim meet. I just need you to know that if I have a panic attack during a swim meet while I'm in the water, I need to get out, or on deck, even if I'm on deck waiting for for my race, I need to be able to leave the pool area. And the coach said, that seems like a fundamental alteration for a student participating in this extracurricular activity to not be able to participate in the extracurricular activity. So they said, you cannot engage in competitive swimming if you're going to leave the pool. I need you here. I need you on deck. I need you in the water. And so the coach said no. And the family filed suit in this case. They didn't file an OCR complaint. They went straight to federal court and they alleged that this was a denial in a, of a reasonable accommodation in the athletic program, and that it violated the student's rights to access the school's program under 504. And the court said, no, family, you are not entitled to the accommodation of leaving during the swim meet if you're on the swim team. You cannot leave the pool in the middle of a competitive swim meet, because staying in the pool is an essential aspect of being a swim team member. So that was held to be a fundamental alteration. In that case, the coach was right. The court concluded the coach was right. But this is a pretty extreme example, and if anything, it should demonstrate that you do have to go pretty far to say that it's a fundamental alteration, but not being able to participate in the activity is going to be a fundamental alteration. The other thing, and I alluded to this earlier when we talked about bringing somebody on the DC trip, but the other thing that's pretty hard to defend is when you say it's expensive, something costs too much. When OCR is considering whether something is reasonable or unreasonable in terms of cost, they are looking at the district's entire budget, the whole thing, not just that program, not just that trip or that activity or that one little thing. What they're, whatever they're asking for, whatever accommodation they want that's costly, it doesn't usually look unreasonable in light of the entire district budget. So you will probably lose on saying that this is unreasonable because of money. So no bright line test on fundamental alteration, but those are some takeaways. All right, next question we get: must a district conduct a manifestation determination for a student protected under 504 before imposing a disciplinary removal of 10 days or more? So the answer to this, and I again, this is another, I said these are all common questions we get. We get this question all the time. The answer is yes. Yes, you do. If it is more than 10 days. If it's fewer than 10 days, just like under the IDEA, that's not a significant change of placement. And so it is not required. But also, just like under the IDEA, if you've got a series of suspensions, if you've got this pattern of removals that's, based on the same kind of conduct, if you've got a series of removals that cumulatively totals 10 days in the same school year, that is considered a significant change of placement. So you do need to go back and look at the student's suspension history for the school year. But this MDR concept, a lot of times people think that that is only a requirement under the IDEA. It actually predates the IDEA. This MDR concept existed in 504 long before the IDEA was ever even adopted. And, the idea, again, like I said, what's going to guide all of our decisions is going back to that discrimination concept. If you take a kid out of your educational program because they engaged in conduct that is a manifestation of their disability, that's the ultimate act of discrimination. They're doing something because of their disability, and you are removing them from their educational program because of that. So, what do? You're going to have your MDR. You're not, make sure you're not denying the student access to your program because of their disabling condition. So yes, you do have to do an MDR for 504 kids. So go back and think about the first or second slide today, the individuals who are entitled to protections of the act, but who maybe don't require a plan. Somebody who qualifies, somebody who has a record of impairment, somebody who is regarded as having an impairment. If they're entitled to the protections of the act, they're entitled to an MDR before they're excluded. Now, this doesn't come up often, but it does occasionally, so you should be aware of it. When the family's lawyer says, but wait, my client had a disability 8 years ago. You can't discriminate, against that person. So sometimes you have to go back and find your records. But the big difference under 504 from the IDEA, even though a lot of these concepts are similar and shared, is that if you do have an MDR and you determine that the conduct is not a manifestation of their disability, so you're going to exclude them, there's going to be a significant change of placement, but you can do that because it's not a manifestation. Their services stop. So unlike the IDEA, if the student's on an IEP, you continue services, right? You give them day 11 services. Under 504, there is no requirement to continue their education during the period of removal. So that's the big difference. So the concepts are the same. We're not going to remove someone from school, from their educational program because of their disability. That's discrimination. But if the conduct is not because of their disability, we don't have to continue to provide services. So big, big difference. Now, the exception to that, of course, because again, this is a non-discrimination statute, is that if you routinely provide education to your to excluded kids in general. So if you routinely provide some kind of alternate education, whatever you do when your students are expelled, if they are gen ed kids, then you're going to continue education to your students with disabilities under 504 as well, because you're not going to treat them differently, because that would be discriminatory. So always go back to that fundamental concept that this is an anti-discrimination statute. So, if you've got ISS or some kind of alternative programming that you make available to your non-disabled students, then you need to make those same options available to your students who are protected under 504. So who has to be at the MDR meeting? Same requirement as an evaluation. It's not an IEP team. You don't have those stringent requirements. So who decides this? It's going to be people who are knowledgeable about the student and the disabling condition. So it's not going to be a gen ed teacher, special ed teacher, district rep. Those requirements don't exist under 504 for an MDR, just like they don't exist under 504 for your evaluation team. So, you're going to get the people who, with a common sense analysis makes sense to be there to make this decision. You're going to decide whether or not the conduct is a manifestation of the disability. If it is, then you're not going to remove the student. If it is not a manifestation of the disability, then you can move forward with your discipline, use your same, disciplinary due process that you always use. And then you don't have to provide services unless you provide services to gen ed kids in that same situation. All right, next question. Does failure to recognize harassment violate section 504? The answer to that is yes. And again, this is one that I do think confuses folks, and I can understand why. So what we have been told by the Department of Education back as far as, 2000. So we're talking, 24 years ago, that disability harassment, which includes the discrimination or harassment of students based on their disability, could interfere with their receipt of FAPE. So if a child is bullied and they're not accessing your programs, then you have a situation where a child is denied access to your federally funded program because of their disability. So there are a series of Dear Colleague letters on this. There's one from 2000, there's another one from 2010, and they're very sweeping and extensive. And what they say is that you have an obligation to address the bullying and the harassment and to take steps to remedy that conduct. And this slide shows an outline of what your response should look like. Got a little flow chart. So, we can't control what students do. We can teach the golden rule. We can tell them to be kind. We can, tell them to be nice, but we can't control whether or not they are. But what we can control is our reaction as a district to that type of conduct. Ultimately, when there is liability in a district in a bullying and harassment situation, it's usually where it's being litigated, and you have a student who says they're being denied their education because of the bullying, or worse, you're looking at a tragic situation, picking up the pieces, after a student suicide. Or, and the parents come back to you and say, you knew this child was being bullied, you didn't do anything about it. And those situations are tragic. And they often end up with liability. And, when they end up with liability, it's when the school district can't show that they responded appropriately, that they followed their board policy. They were put on notice and, didn't take action, or dismissed it, or, didn't really conduct an investigation. So you want to show that you responded appropriately, that you followed your policy. You want to document. And then if there is a finding, you're going to do something about it. Again, like I said, with the request to evaluate, you may have, policies that suggest that things be, that you get a formal complaint in writing. And a formal complaint in writing is great, but an informal complaint of bullying and harassment still needs to be addressed. If someone brings to your attention that there's a bullying or harassment situation going on with one of your, whether it's a student with a disability or not, but that's outside the scope of, of this discussion. But there's still, if you look at your board policy, an obligation in most board policies that whoever receives that report or comes across that information, reduces it to writing, gives it to the appropriate person in your district, and that you follow your process. So you're going to want to, respond immediately, bring the parents in, talk to them face to face. If you can, if you're limited to a phone call or a video, that's fine, but face to face meetings are so much more conducive to a real discussion about something like this. Find out what the problem is, conduct an investigation. Even if your gut instinct is, I don't think this is really happening, conduct an investigation. Do what you need to do to look into it, look at the policy, see who the appropriate administrator is to do that investigation. If you've got your disability compliance officer, it may say designee. So, they may want to appoint someone else to do it. If there's somebody else who's more appropriate, might be the high school principal, whoever is most equipped to conduct this. And you also probably have multiple policies that have different procedures. And especially now with Title IX, you've got your Title IX procedure, you've got your disability harassment procedure, you've probably got a general, hazing, bullying, intimidation policy. But look at those policies. The procedures are going to be different. Figure out which policy applies to your complaint. If you don't know, contact your legal counsel and then follow that policy. Do your investigation. And an investigation, it sounds like a really formal word. It might be very simple. It might be just interview the student. It might be interviewing a bunch of people, might be pulling video, but whatever your facts are, do your investigation. And then on the next line, you're going to document that investigation. And if there is a finding, the middle box on the bottom line here, this is the meat of it. You're going to stop the harassment. You're going to prevent its reoccurrence and eliminate the hostile environment. That's what you are charged to do if you determine that bullying or harassment is taking place. And then on the last step for students with disabilities, there's probably something that can be done with the student's 504 or IEP, depending on the situation. If they're being bullied or if they have been bullied or harassed, they might be entitled to comp ed. It might be that they need social skills training. It may be part of the reason they were bullied, while it's certainly not an excuse, but it might be because they didn't understand personal space. So they stood really close to people and they were touching them and then other kids made fun of them. Those are the kinds of things that happen to this vulnerable population. Maybe it's because of hygiene. There might be ways to address the prevention step of that in their 504 or IEP. So, convene the team and talk about that. Okay, our last FAQ is what can we do to lessen our complaints? We've talked about some proactive things you can do and the importance of looking out for those red flags. So what I'm going to talk to you on the next slide is things not to do. These are the things you do not want to do. Not provide procedural safeguards. That's a requirement. You don't want to fail to take that important step. Putting an obligation on the parent to trigger the evaluation. Think about that 2016 Dear Colleague letter I talked about on ADHD. Your staff are the eyes and ears of the district. You have the child find burden of looking for children who need special education and related aids and services, right? So that's your child find. You need consent. And if they refuse, you've met your child find obligation. So that's great. But you have to be proactive when you suspect that a child may need special education and related aids and services. So don't wait for parents to come to you. Make sure your staff know that if they have reason to believe that the child is going to qualify or is eligible, then you are going to go after parent consent. And then if you don't get consent, you're going to document that. And that will cut off your obligation. But that doesn't mean you can wait for parents to ask. Don't fail to train your staff. Don't staff need to know what's at stake. What they're seeing may be putting us on notice of child find. So training is extremely important. Not training on 504, not knowing who your 504 compliance officer is and who they can talk to. So here's one that's not on the slide. not using the phrase, tell me more. If you are hearing from a parent or from a staff member, something that, something about a child, give that open-ended opportunity to get the most information you can have. You're never going to go wrong with getting more information about a child. So tell me what you think. If they want a therapy dog, let's talk about that. Why does the therapy dog need to be there? What's the dog going to do for the child? Why? Engage in that interactive process. We get the request for emotional support animals that are not service animals pretty frequently. And that's another presentation, but if you get a request for the iguana to come to class, or the hamster, we actually did have a hamster request for a preschool student as an emotional support. If you ask why and they explain, well, this is what my child needs to reduce anxiety. Okay, well, let's have an interactive discussion about other accommodations we can provide that will reduce anxiety, and try to work that out that way. Another big tip, it's the last one on the bottom corner of the slide, is don't make the child responsible for the plan. I see that sometimes and I see this in IEPs too, where there is something where the child has the responsibility of taking a certain initiative, like the child will check in with the teacher at the end of the day to make sure their assignment list is accurate. Then if the student doesn't do that, you're out of compliance. So you want to write it in the opposite way. So the student is getting the support that the teacher will check that list. But the sole responsibility should not be on the student to get something done under the plan. And that's not to say that there's anything wrong with fading support and working toward independence. Those things are all important too. But if a student, if there is something where you've got the student responsible and they're not seeking that accommodation on their plan, you should put the team back together. And yeah, I think this is the question that just popped up about a student and teacher being responsible for fading support. Absolutely. There's certainly nothing wrong with that. That's when you want to monitor it though, because if the student isn't doing it, you're out of compliance. And so, that's when you put the team back together and see if that accommodation should really be there, because if it's not, it sounds like it's not working. So just be sure to, to monitor those situations. All right, it is 11:07, and due to our technical difficulty, we are a little bit behind. I think, Maya, can you skip? So the next slide is about the proposed rules, which actually this slide should be updated because that proposed rule is now final. But the Department of Health and Human Services has now published, they've gone through that rulemaking process we've talked about, and there are new rules implementing 504 in the Health and Human Services context. That doesn't apply to you, but because if you go to the next slide, if you go to the Department of Education has also put out notice of rulemaking on 504 works. Well, who knows what's going to happen now after the election and with the change of administration, but we were looking at potentially new 504 regulations coming out from the Department of Education, and the HHS regulations kind of gave us an indication of where we thought the Department of Education might be going with it. Let's go ahead and skip all of this though, in the interest of time, and move to our scenario. Okay, so I'm going to read you a scenario about 3 children who are new to your school district, and then we're going to talk about what you would do. Okay, so bear with me. This is a little long. I'm going to take a little sip here of my coffee, so before I read it. Okay. So what would you do? This is a new family has moved into your school district, and only 2 weeks later, you have 3 voicemails from the mom, one regarding each of her 3 children. And although the children's enrollment paperwork doesn't say anything about any of the children having a disability, mom is now requesting a variety of accommodations for each of her children. So her first child, Fishy Philip, is a first grader, apparently has a serious seafood allergy that is triggered not only by the ingestion of seafood, but also by skin exposure to seafood. In mom's voicemail, she shares with you that in the past, this allergy has caused anaphylaxis, a severe whole body allergic reaction to a chemical that has become an allergen. Symptoms of anaphylaxis can include closed airways, hives, nausea, vomiting, heart palpitations, and even unconsciousness. Philip's mom is requesting a healthcare plan to ensure that his lunchroom will be completely seafood free and that his lunch table will be thoroughly wiped down before he uses it, and that he will have access to his EpiPen at all times in school. Now, other classmates at school have food allergies, so some of these requests are not new to you or your school staff. Therefore, you suspect that your school staff will not see a need for a health plan for Philip. But after her voicemail to you about Philip, mom wrote you an email complaining that for the second fish stick Friday in a row, another student has approached Philip's lunch table waving a fish stick in his face. And she writes that Philip is now very anxious about going to lunch because of the incident. So mom indicated that she has had great difficulty getting him out the door to school today. And Philip is telling his mom that he will not come to school tomorrow. So that's Fishy Philip. The next one is Wheezing Wendy. And I'm sorry, Maya, I think there's a slide for each child. Yeah, sorry. This is Fishy Philip, fourth grader. Okay, now we're on Wheezing Wendy. Thank you. Wheezing Wendy is a brilliant fourth grader, brilliant, and she has asthma. And in mom's second voicemail, she tells you that Wendy's asthma seems to be exacerbated by strong smells, such as cleaning supplies, or the new Katy Perry perfume that nearly every fourth grade girl seems to drench herself with every morning. So the other day, she had an asthma attack right before a big test, and her mom had to be called to school to administer an inhaler to her so she could go back to class. Now, your school nurse has shared with you that she tried to explain to mom that she could fill out a form so the inhaler could come to school with Wendy, but mom is insisting that Wendy have a 504 plan instead. Wendy missed a substantial amount of school last year due to asthma-related issues, and her inhaler is typically all she needs. Your school nurse thinks a healthcare plan and administration of medication form would be sufficient to address this issue. And then we get to the third voicemail regarding gluten-free Gloria on the next slide. So Gloria is a seventh grader, and she's on a gluten-free diet due to her problems concentrating while in school. Mom, in her quest to help her daughter, found the diet on the internet. Mom heard from Gloria's teachers that she's had trouble organizing tasks and activities, completing assignments, paying attention in class, but has noticed that after going on this gluten-free diet, her grades and focus seem to have improved. So the internet was right. However, the other day, Gloria apparently ate a birthday treat that a classmate passed around, and then she scored very poorly on her tests for the rest of that day, even worse than she had been doing at her old school, where she wasn't exactly a stellar student. So mom wants a guarantee that the school will maintain Gloria's gluten-free diet at school and wants this to be accommodated through the National School Lunch Program. Gloria's teacher tells you that she offers an alternative allergen-free treat for every student, but that Gloria turned it down and knowingly went for that cookie. All right, so what we need to figure out is on the next slide, I think. Yes, okay. We want to figure out whether any of these students are suspected as disabled, and if so, what is their suspected disability? And then we want to talk about what the next steps are for each student. So let's start with Fishy Philip. The first question is Philip likely disabled? So on the next slide, your choices are Philip is disabled and I would develop a healthcare plan. Philip is disabled and I would develop a 504 plan, or Philip is not disabled. And if we were in person, I would take a show of hands. But since we're running out of time, I'm just going to cut to the chase and click on the slide. Hopefully the right answer will pop up. It's not A. And click one more time. It's not C, it is B. Philip is disabled. His allergy is severe. It renders him substantially limited in the major life activity of eating and breathing. So he is going to qualify. And we could address this under a healthcare plan. But you might not be checking all the compliance boxes if you do that. I recommend going through the whole 504 process. If your district has OSBA policies as its policy service, your policy probably says that you will address all food allergies on a 504 plan. That is what OSBA policies typically say. So you should evaluate, you should convene a group of people who are knowledgeable about the student and the data and the placement options, and then write a plan. So on the next slide, let's talk about what this plan might look like. Do you think it's appropriate to, to create a seafood-free lunchroom? Is it appropriate to have Philip eat by himself? Do you think neither one of these is appropriate? So let's see. Do you think neither? All right. So, well, let's go back and think about this. There are circumstances where the severity of the allergy requires you to have an allergen-free environment. I would want to have the best medical advice I can get. Ask for a release and talk to the doctor. There is a case out there on a peanut allergy where the doctor said, excuse me, it was the worst peanut allergy he had ever seen. It's airborne. If it's in the building, it can go through the HVAC system and this child could die. That was what the doctor said. And so this particular district adopted a peanut-free building policy for the building where that child attended. And believe it or not, that was challenged by another person, a parent, who thought that was unreasonable. I'm sorry, I always shake my head at this, but this parent thought that their child's right to eat peanut butter was more important than the other child's right to go to school and live to the end of the day. But the court disagreed with that parent, said this is reasonable. The medical evidence established that the child's allergy was severe and life-threatening. That's what we want to know. So you're not going to have a severe and life-threatening, situation with every allergen, of course, but you're going to want to get the best medical advice you can get. But in this case with Philip, the information you have is that it is severe. He needs an EpiPen. He can't breathe. So, again, get your best evidence. If you don't get consent, you utilize the evidence you have. We are also told in the USDA guidance on food allergies that you're required to accommodate this. So we have another law besides 504 that requires the accommodation. So what about the option of having Philip eat alone? Hopefully nobody would have chosen that one. And the reason for that is because that's not his LRE. That LRE requirement also appears not only in 504 and in the IDEA, but in the USDA lunch program guidance. So, in the 504 plan, if you're going to create a seafood-free lunchroom, there should be procedures in place, like who's responsible for wiping down the table, who's going to take care of making sure that this is a safe space for Philip. There should be training of the staff on the response in the event of exposure and how you're going to handle notification, if there is an exposure. So on the next slide, what about offering an alternative to Philip? Let's say we end up determining that it doesn't have to be completely seafood free. We're still going to offer Fish Stick Friday. What about offering an alternative food for Philip on Fridays? Should we make him pack his lunch, or are we going to offer an alternative meal on Fridays? Well, the USDA lunch programs require you to accommodate him if you have medical evidence. Now, if it's not supported by medical evidence, you have the option to provide a substitution, but not the obligation. You're only required to do it after receipt of the medical obligation. So if mom provides, medical documentation of this fish allergy, you have to offer an alternative meal. So on the next slide, what other steps might you take to respond to mom's concerns? Consider IDEA eligibility because of the anxiety. Consider whether he's being harassed and bullied. Conduct an investigation into the fish stick incident and discipline the other student if necessary. Or D, all of the above. Yeah, I'm going with D here. And usually when I give a list that has an all of the above, that's going to be the answer. Actually, is there a way to go back so you can show the other answers, Maya? If not, it's no big deal. But yeah, so thank you. If you look at all of these, I mean, there's more than just the suspected disability here of the seafood allergy. There are harassing and bullying concerns. If kids are waving fish sticks in this kid's face because they know that he's allergic to fish sticks, that's not nice. And now he's not coming to school over it. So the conduct is interfering with his access to the education, to your educational program, and that is a problem. Okay, let's move on to Wendy. I'm going to try to go fast. I know we've only got 10 more minutes. Okay, how many of you think that Wendy is in no way disabled? If you could show your hands, we would do that. But it does sound like she has a, she's substantially limited in the major life activity of breathing. She has a potential chemical insensitivity. So you can have mom come complete an inhaler form. You can request consent to do an evaluation to see if she qualifies for protection under 504. You can request consent to consult with Wendy's doctor, or you can do all of the above. So again, I already told you the answer because I told you anytime there's a bunch of choices with all of the above, it's going to be all of the above. So yes, I would do all of these things. Recognize that having a completed inhaler authorization form on file may not sufficiently address all of Wendy's issues. That may be some of the practical issue presented, so mom doesn't have to come to school. But, from a child find standpoint, it will not eliminate the need for evaluation and possible development of a 504 plan. So like with Philip, you're going to want to convene a meeting, give the parent a copy of the 504 safeguards, request permission to conduct an evaluation, because, in addition to asthma, it sounds like Wendy may have multiple chemical sensitivity issues. So you're going to want to try to get more information from the student's medical provider, determine the existence and nature and extent of the disability, identify, whatever recommendations her medical provider has. And there may be, consideration of medical information as triggers. So, what environmental irritants are causing the problems? In what situations is she exposed? How long must the exposure be before before the problems start to arise, and what will happen upon exposure? So the results of the evaluation will also provide you with more information on what kinds of accommodations are appropriate. So it's important to request to consult with Wendy's healthcare provider, so any information can be gathered directly from them and not, having mom as the middleman. Mom may be filtering some of that information, not necessarily in a deceptive way, but, because they don't necessarily know what is important for you to know and what's not important. And I've also found that parents sometimes, in an abundance of very understandable caution, sometimes perceive health risks to be a bit more severe than they actually are. Not always, and I'm certainly not throwing any parents under the bus, but it is really helpful and important to be able to communicate directly with the provider if the parent will let you. That's the way you get the best medical evidence that you have. All right, so lastly, let's talk about poor little Gloria. She really wanted that cookie. She didn't want the non-gluten treat. That's not nearly as good as a birthday cookie. So first, do you suspect that she's disabled? Do we need a 504 evaluation? Do we need an IDEA evaluation? Do we not suspect that she's disabled at all? So she doesn't appear to have celiac. She doesn't even appear to have a food allergy. This, if you remember from the scenario, mom has Gloria on a gluten-free diet because she read on the internet that she would concentrate better if she did not consume gluten. So, is there some kind of a medical need there? I don't know, maybe. It sounds like a little bit of a, wacky internet fad, but we don't know that. But it doesn't really sound like a food allergy. But think about what the facts are here. There's more to it than the gluten. Her teachers have been observing some things. Gloria hasn't been in the district very long. We do know that it said that Gloria was not a stellar student at her last school, right? And her teachers have been observing things like she's having trouble organizing tasks. She's having trouble completing assignments. She is, having difficulty paying attention. She's not focusing. Does this sound a little bit like that Dear Colleague letter from 2016? We're the eyes and ears of the district, and the teachers are identifying behaviors that sound a lot like ADHD. They sound consistent with ADHD. So think about that Dear Colleague letter and your child find obligation. Even though mom is saying gluten solves her problems, we're looking at this student in her unmitigated state. Let's look at what Gloria looks like when she doesn't fail to consume gluten, like a little double negative there. I don't know. I don't think that the gluten-free situation is necessarily a disabling condition. I'm probably not there yet based on the information that we have so far, but I think I'd want to know a lot more about the ADHD. So I would want to do an evaluation. So on my next, so I guess the answer to this question, I'd say you could do a 504 or an IDEA evaluation. It's going to be, how you evaluate is really a local decision. But I think you need to try to get consent to evaluate and see what you can find out about this ADHD and see if she qualifies. All right, so the last question that I have is, would you include a food substitution plan? And so your choices are yes or no. So like I said, with the fish, if you have medical information, so this really is gonna depend on what, whether or not you end up getting medical information, if you have a release, if you talk to a physician, if mom provides something from a medical provider, when you're doing your evaluation. But if you have medical documentation of an allergy, then you are required to provide a food substitution, for Gloria. So you're gonna need to do that. But if not, then it's optional. I mean, and what you have is, I don't want her to have gluten. This is not based on anything medical. This is based on my internet sleuthing. So it would be optional, but not required here. If you click, I think it'll pop up. I would not include it. Yeah, so that's where we are on that one. And again, that's going to change if you end up getting medical information, because that changes the analysis. So that brings me to the end